this limited power of attorney was to confer the authority to execute on behalf of Bank of America certain documents. Is that correct?
Yes.
And the documents are specified here as what, Mr. Stenman?
Assignment of mortgage / assignment of deed and substitution of trustee.
Do you know how long this limited power of attorney, I'm sorry, strike that. First of all, can you see the date of the execution of the limited power of attorney?
Yes.
What date is that?
April 5th, 2010.
To the best of your knowledge, are you still signing documents on behalf of Bank of America pursuant to this limited power of attorney?
Me, no.
Do you know when that ended?
It might have been some time ago. It might have been more than a year ago, maybe 2 years ago.
Do you know the reason why you stopped signing under this limited power of attorney?
On advice of counsel.
You're looking at Exhibit 23, Mr. Stenman. Can you tell me what 23 is?
Yes.
What is it?
Appointment of successor trustee.
And is 23 one of those appointments that you signed through the power of attorney
Yes.
that we just previously discussed in Exhibit 22?
Yes.
Okay. And what is the date that you signed Exhibit 23?
September 25th, 2012.
Does that jog your memory as to when you were signing these appointments pursuant to that power of attorney?
Yeah, it was, like I said, about a couple years ago. Maybe not quite 2 years ago.
All right. Take a look at Exhibit 24 and tell me if you have seen 24 before coming into your deposition today.
I don't remember seeing this exhibit.
If you read,
Unless it was in what was served to us in, when was that? We received service of process from this office, and there were a bunch of documents in there. I don't remember this being one of them.
okay, so you're looking at it for the first time? It
I think
seems
so,
like. Okay.
yes.
If you read the contents of Exhibit 24, does it jog your memory as to the fact that Ms. Lucero accepted a temporary loan modification in September of 2012?
We were advised to close our file as a result of a modification, so we were aware of it, yes.
When were you in fact advised of that fact?
I don't have the date. I wish I could remember the date.
It would be reflected upon the case notes.
It would, and I have a copy of the closing instruction too.
Do you recall from whom you learned that she has accepted the loan modification?
Well, the instruction to close the file would have come from Stenman.
Okay. And would that be the only entity you would take the direction to close the file from?
Yes, because they're the servicer of the loan, they would tell us. They would be the ones to give us instruction on whether or not we could take our hold off and close the file.
Would you have accepted instructions from, say, RCO as the attorney for Stenman regarding the result of the mediation?
No, because the servicer has to close it in the vendor system, and we don't want to have the vendor system open and our file closed, so we would want the instruction to come directly from the servicer, because they would close that system and then both files would be closed. Otherwise, they could have an open file and they'd think we were doing something for them or monitoring something, and we wouldn't be.
Once your, strike that. Do you know when this Lucero file was closed by your system? By what?
My system would tell me. I'm struggling with the date because I can't remember what it was this morning, but
would it be soon after Sanlar sends you the information? Or would there be some kind of a delay between what?
It's possible that if there was a trial mod, they would wait for the trial mod to be completed and the loan modification to be processed before they would tell us to close it, because trial mods fail all the time. So I would have to make an assumption that they would tell us to close the file after they've concluded the modification.
When you close the file, particularly in this case with the Lucero foreclosure, did you earn the full fee as trustee?
No, we would have billed a prorated amount, because the only milestone we completed was the NOD milestone. So it would have been short of whatever the allowable fee was.
Okay. So the answer is that you did not get the full fee. Mr. Stenman, I would like you to review Exhibit 25.
Okay.
24.
Oops.
Is it 24?
I think we were on 25.
25.
It should be 25. Are you sure?
What was the last one?
My mind, sorry about that. We're rushing you. Please take a look at Exhibit 25, Mr. Stenman.
Okay.
Do you recognize it?
Yes.
What is it?
It's a reinstatement quote.
Do you know, well, obviously you did not sign, or you were not responsible for drafting this letter, right?
It came out of our quote group, quote team.
Okay, and how do you know that?
Because the party that's name is listed as part of the quote team.
Heidi?
Heidi Danseglio.
I got you, okay. What is the date of Exhibit 25?
November 14th, 2012.
So can you explain to me how Exhibit 25 came about, if you know? What would trigger Exhibit 25 to be sent to Ms. Lucero, or Mr. Glidden in this case?
Two things come to mind, either a request from the borrower or a request from RCO for the mediation.
Okay. And in looking at 25, does it refresh your memory at all as to when you actually closed the file on Lucero?
Well, it would have been after that date.
So it would be after November 12 of 2012.
Yeah, yes, because if they use this for mediation, they have to go through the mediation before they can agree to a mod and then do the third party, the trial plan, and then accept the mod.
The opening paragraph says that this letter responds to your request for reinstatement figures good through November 15. Do you see that?
Yes.
Do you know for a fact that the borrower, in this case Ms. Lucero and Mr. Glidden, actually requested a reinstatement figures.
My review of the notes show they did not request reinstatement figures.
So how did this Exhibit 25 get generated by Northwest and sent out?
It's my understanding it was a request from RCO for the mediation.
And so explain to me the rationale behind that,
Object to the front.
if you know.
RCO will quite often ask us to request reinstate or pay off figures for the mediation because they're required at the mediation itself.
And the purpose for that is?
So that everybody in attendance, well, I'm guessing, but for everybody in attendance to know what the actual default is.
Now, when you look at the second page of Exhibit 25, you see a trustee fees there.
Yes.
And do you see all the charges that are listed there?
Yes.
To the best of your knowledge, were these charges taxed to Ms. Lucero? Do you understand my question?
We would have invoiced these charges to Stenman, yes.
Going back to your policy, the one that you testified, regarding the sequence of recording for assignments and appointments, is that practice still in place today?
No.
Why is that?
Because we want to be, try to be transparent and show that the dates of execution are in alignment with other documents.
Do you know when that change was implemented?
I think in between April and May of 2013, I want to say.
And that's well after this case had occurred?
Yes.
That was not a result of frivolous lawsuits or anything like that, was it?
I don't know.
I learned that for a time, your company, Northwest Trustee, was conducting trustee sales on its premises in Bayview. Is that correct?
Yes.
And the sales were taking place in the garage of the building. Is that correct?
Yes.
And does that practice still in place today?
Yes.
And is there, in your earlier testimony, you said that the sales would be taking place at the courthouse or public places, correct?
Yes.
And is it Northwest believe that its garage is a public place?
Object to the front.
If you know.
We believe there's, yes, access to the public. Anybody may attend our sales.
And to the best of your knowledge, has it been any complaint, lawsuit regarding that practice of conducting sales at your garage?
Against Northwest Trustee?
Against Northwest Trustee, yes.
I don't know. I don't know for certain that there has.
Are you aware that your company has a policy of, strike that. The last few times that I came up on the physical building that you have testified as the building that you share with others, including RCO, I was subject to having to give up my driver license. And my driver license was copied. Are you aware of that practice by Northwest Trustee?
For what purpose?
To gain entry into the building.
I'm not aware of a practice like that. That doesn't mean that it doesn't exist, I'm just not aware of it.
When we walk into your building, there's a reception area. Are you familiar with that area?
Yes.
And there are people who man or, work in that area.
Yes.
Are these people employees of Northwest Trustee or RCO?
I'm I don't know if they're employees of RCO. They're not employees of Northwest Trustee.
Who would they be employed?
I don't know. They may be RIM employees, they may be RCO employees. I'm not sure. They don't report to me and they're not on my payroll.
Go ahead.
That's okay.
Let's take this case as an example. When Ms. Lucero went into mediation with RCO, are you aware that she submitted substantial financial information for purpose of mediation through RCO?
No,
You're not aware of that at all?
I don't have access to their files and I wouldn't know anything about what's been submitted in a mediation.
How do you and RCO communicate about cases that are in mediation?
Well, we're like any other trustee. We get a certificate at the end of the process. That certificate is transmitted to us.
By RCO?
Well, by whoever represents the beneficiary in mediation.
But as I imagine, the mediation process takes some time. During that period of time, as your testimony, as to the testimony you just gave, is that there's a time span between the case being referred to mediation and you closing the file due to successful mediation, or there's a successful loan modification trial payments. Is that correct?
Yes.
During that period of time, are there any communications between you and RCO as the lawyer for Stenman?
We might ask what the status of the mediation is so that we know whether or not we should be postponing as opposed to canceling the sale. Some of the mediations take a lot of time, and we only get 120 days postponement time period.
What happens when the mediation takes longer than that 120-day postponement period?
Then the sale's canceled.
In your review of the case file for purpose of your deposition, do you recall seeing any communications between RCO as attorney for Stenman and Northwest Trustee about the Lucero's mediation specifically?
Between who?
RCO and Northwest.
I mean, communications about the status of the mediation?
Yes.
I didn't see, I can't remember if I saw notes about it or not. We have events that we track till we get the certificate, so we track their events. I don't know if there would have been communications or not with the RCO. There may have been.
But
I don't remember seeing them in the file.
Okay. But if there were, they would be reflected within your file, would they not?
It could just be reflected in the form of reprojected events.
What does that mean?
So if we ask when the hearing date is, because we know from the hearing date that the certificate has to be issued within a certain amount of time. So we follow up to see if we can get a hearing date so that we know where we're at with it. And then once the hearing, so if the hearing's not scheduled yet, we'll reproject our event so that it's another 2 weeks or another 30 days. In our system, our events allow us to have a scheduled date and an actual date. We can reproject the scheduled date until we have an actual date to complete the event.
Gotcha. Okay, so you just put a date in there and then replace it with the actual date by reprojecting.
So it's an event that's not complete and there's a projected scheduled date, and if that date isn't going to take place, it gets reprojected until we have an actual date.
Okay. Now, in the very beginning of your testimony, I asked you about the placement of the property into USAforeclosure.com. Do you recall that testimony?
Yes. And
your testimony is that the information gets fed to USAforeclosure.com and it goes onto their own website.
Object.com.
Do you recall?
Yes.
Okay. When does a property get off the foreclosureusa.com system? Do you know?
If it's canceled, it can be removed either manually or we'll show the cancellation and it'll drop off several weeks after the scheduled sale date, so that any interested party can see that it's been canceled.
But that's all it shows is just that the sale has been canceled.
Yes.
It doesn't say anything about reinstatement or successful mediation.
No.
Nothing like that, right? Who is responsible for updating foreclosureusa.com so that the property would get off the track, so to speak?
To my understanding, it's an automated process, so it automatically comes off once it's canceled after a certain amount of time.
And what would be that amount of time, do you
I
know?
believe it's 2 weeks. It could be 4 weeks. It's either 2 or 4 weeks.
And you don't know which time frame applies to this case?
I don't. Well, in this case, we never scheduled a sale, so it never went into the USA site
At all?
at all.
Okay. So the trigger for going on to the foreclosureusa.com is the notice of trustee sale. Is that your testimony?
Yes.
If that notice of trustee sale hasn't been recorded, it would not be on their website at all?
Unless we've issued the notice, it won't be in the site.
The notice of trustee sales?
Yes, ma'am.
In the situation such as this one, where the borrower sues, and in this case, we sued not only the servicers, but also your company and RCO. And then RCO ended up representing your interest in this case. Do you agree?
Yes.
In the representation by RCO of Northwest as a defendant, can I presume that you hand over your files and records to your counsel for purpose of defending you?
Object. Don't answer. Don't ask about what has been exchanged.
I'm
in
not
terms
asking,
of-
I'm just saying that would not be a fair assumption that you would do that for purpose of them representing you.
Don't answer.
What would be the ground for that answer? I'm not asking.
You're
for this
asking
specific-
about what was transmitted by the client to the attorney.
Not at all. I'm
That's
not
how it's
asking
coming
that.
across, so please rephrase that.
I'm asking you whether it's a fair assumption that in the process of selecting RCO as your counsel, that you would have turned over files and records relating to the case to them. I'm not asking you which files, which records, I'm just asking you whether that has in fact occurred. Really? So whatever you want to do, that's the question. Are you going to instruct me not to answer?
Rephrase one more time, please.
Did you, Mr. Stenman, have any knowledge of whether in the process of having RCO acting as your lawyer, handing over files and records about the Lucero foreclosure to your counsel?
I'm going to instruct you not to answer.
And I'm going to go to court and ask for, why would you be, what would be your basis for that? I'm not asking for what was given. I'm asking whether that in fact happened.
Okay, you can testify about whether that happened. Do not testify about anything, the contents or anything regarding what may have been provided.
Yes.
Okay.
We're supposed to have a short break.
Okay.
Pause. The record reflected is 2:39. We're off the record. The record reflected is.
Wait.
Oh, sorry. I thought you were ready. My bad.
No, I need a minute to.
No, of course.
Okay. We're ready when you're ready.
Yeah, of course. The record reflected is 2:48 p.m. and we're back on the record.
Mr. Stenman, the Lucero matter started in 2012. And your testimony is that the closure of the case by Northwest would have occurred sometime after November 14, 2012. Do you recall?
Yeah, it'd be after the mediation, sometime after the mediation. Yes.
You just have no idea whether it,
I don't want to give you a date and then be like way off on it.
okay. In 2012, earlier you testified that RCO had been acting as general counsel from time to time for Northwest Trustee.
Object to the form.
Do you remember that?
As counsel, yes.
And at some point in time, Mr. Katz became your in-house counsel.
Yes,
Do you recall that testimony?
yes,
But you continue to seek counsel from RCO from time to time,
yes,
up to today? Not just in terms of this litigation, but in general?
yes.
And do you consider them to be your lawyer,
If it's a
excluding this litigation?
day-to-day basis, my inclination would go to in-house first.
But if you don't have access, or if there's something else that you need, have you the occasion going to RCO as your lawyer?
Object to the form.
As counsel, yes.
Okay. And in this case, in the Lucero matter, RCO represented the servicer Senlar in the mediation. Do you understand that?
Yes,
Your testimony was that Northwest actually looked through the list and determines that RCO would be the lawyer that represents Senlar in the mediation.
Object to the form.
when I mentioned the list, I was giving you an example of how we know whether or not they're retained as mediation counsel. I don't believe I said that I looked at the list and Senlar was on the list and that we automatically forwarded it to RCO.
Thank you for that clarification. So in the Lucero matter, do you know how RCO was retained to be counsel for Senlar in the mediation contest?
No.
Does Northwest Trustee have any procedures I'll withdraw that question. I don't think I have anything else. I think that's it.
I have a few questions.
Oh, before you do that, I'm sorry, I have one more exhibit that I just want to get in. Sorry. Yes. Mr. Stenman, I'm sorry. I'd like for you to look through 26, which I will represent to you that it's a printout of your company's website. Have you visited your website lately
No.
at all?
I haven't been on our website in about 2.5 years.
Okay. All right. So you wouldn't be familiar with any of the representations here or the contents of this exhibit, I take it?
No, because I just haven't been in there.
I do want to ask you a question relating to one of the pages here that Northwest posts on its website. I'd like to refer you to the page with the community involvement. Do you see that? I know it's very hard to read, I apologize, but I couldn't get the printout to be any more readable than this.
Is it, what page are you referencing?
Right.
Oh, okay,
You see that?
yes.
And you probably, I don't know if you have the answer, but let's just go through this. It says here that Northwest Trustee serves to positively impact the communities where we live and work. We do this by building relationships, inspiring philanthropy, and promoting goodwill both inside and outside the company. Do you see that
Yes.
statement there? Do you have any personal knowledge of any of these activities being described here?
Yes.
Can you tell me what they are?
Well, we regularly, I don't know what the exact dates that we've done it, but we've done Habitat for Humanity, we've done a local food bank. We've done shoes for kids. We've done, there's a Christmas program through a local organization where we give toys during Christmas. Those are the things that come to mind.
As you're recounting that, when you said you have done, does that mean that you gave contributions, money?
Yeah, or done or had drives.
And how does that work?
Well, like we'll have employees. We'll do a drive within and have employees provide toys, for instance, and then the company will do some sort of match, or like the Habitat for Humanity thing. There were several of us that went over. I wasn't one of them, but there were several staff people that went down and participated in that over a weekend. I can't remember the Christian or Catholic charity that we gave to over Christmas, but that was a combination of company match and employee gift. There might be others, but I'm not aware.
Sure. To the best of your recollection, has Northwest ever contributed in any way to any nonprofit legal aid organizations?
Nonprofit legal aid, not that I know of.
How about in the prevention of homelessness?
Well, Habitat for Humanity would be an example of an attempt to help homelessness.
Right.
But I can't think of any other off the top of my head. It's not something that I coordinate.
If you could look at Exhibit 26 again, the front pages, if you don't mind, Mr. Stenman. My perception or my reading of the website is that it features the services provided by financial institutions, credit unions, investors, title insurers, et cetera, et cetera.
Object to the form.
Do you recall any efforts or publications by Northwest Trustee to provide transparencies to homeowners
Object to the form.
who are subject to foreclosures?
Object to the form.
I guess I'm not sure what you mean. I think in our notices we try to be as transparent as we can. I don't think we're going to create additional attachments for notices that are required by statute.
Okay. So your position is that you do no more than what the law requires of you.
Object to the form.
Is that correct?
And with respect to foreclosures, yes.
And you look no further than what the servicers provide you with when they provide you information on foreclosures.
Absent some sort of dispute, if there was a dispute, we would request additional information from the servicer. That information would be reviewed by an attorney before a response was made. If we had a particular issue with the response from the servicer, we would take that up with the servicer.
But that's the exception. You only act.
Well, it happens all the time, but yes,
You only act when there is a dispute.
yes.
Okay. That's it? That's all I have.
Well, I guess I'd want to amend that. If I got a referral from somebody and it had a $5,000 balance, I would want to question why they're foreclosing on a $5,000 balance. If the balance was twice the face amount of the deed of trust, I'd want to know why there's a balance of twice the amount of the deed of trust. So I think it goes a little beyond just what the servicer provides. There's the title record as well, and that speaks, that has to be reviewed, and everything has to be in alignment in order for us to proceed.
So you're speaking of the things that are obvious to you. For example, when you said, the balance is $5,000 and you're trying to foreclose, that's real obvious. And when you perceive an obvious error or discrepancy, you take it upon yourself to look further, correct?
Yes.
And somehow during this deposition, we've talked about a couple of different areas whether minor or major errors escaped Northwest trustee, is that correct?
Object to the form.
Well, I don't know that I would characterize them as errors.
Okay, so for example, when I show you the lack of the notary oath on one of the documents, on one of the exhibits, do you recall that?
Yes, I believe my answer was I'd consult with legal counsel to see if there was an issue with it. I don't know if there's an issue with it. I don't know if there's a legal issue with it.
But the fact of the matter is
That
that
doesn't mean it's an error. If I consult and I'm told differently, then
Right.
we would have opposing views of that.
Sure, but the fact of the matter is that you never caught that. You never caught the fact that there was an apparent omission, if you want to call it an error, and you didn't catch it, you didn't deal with it.
Object to the form.
The notes reflect that we didn't bring that issue up. It wasn't addressed.
Right.
I don't know if there's an error.
Okay, that's fair. Anything else that you want to? Okay.
Okay.
Okay. The record reflect the time.
Well, I have-
You have questions now,
Yeah.
okay. Actually, I'll let it run straight through, that's fine.
So earlier you testified, and let's just go back for reference to what was marked as Exhibit 5, which is the notice of default that was done in the Lucero matter. And you testified, and the document reflects on its face that it was done by Northwest trustee as the duly authorized agent of Senlar FSB. You recall that testimony?
I'm trying to find the exhibit.
Okay, sorry. Exhibit 5. We had you refer to it recently, so you may have pulled it out of order.
Out of order, yeah.
Okay.
So you recall that testimony? Do you want me
Yes.
to repeat?
No.
Okay. At the time of this notice in August of 2012, was it the regular course of conduct between Northwest trustee and Senlar that Northwest trustee would issue notices of default on referrals received by Senlar as their duly authorized agent?
Yes.
And are you aware of any circumstance where Senlar ever objected to Northwest trustee acting as their agent for the purpose of transmitting the notice of default?
No.
Your earlier testimony also referred to, you used the term milestone when you were talking about the way a file is billed. Do you recall that testimony?
Yes.
And I believe that you testified that transmittal of a notice of default is a milestone.
Yes.
Is that correct?
Yes.
So in terms of billing foreclosure files, milestones, am I correct in concluding that milestones are how you determine the amount, the prorated amount that you would bill the servicer?
Yes.
And so when we're speaking about milestones, is recording an appointment a milestone?
No.
Is recording an assignment a milestone?
No.
So the fact that you would have recorded the appointment or the assignment in a foreclosure or in this foreclosure, would Northwest trustee have collected more because those two documents were recorded when all was said and done?
No.
The looking back at Exhibit 25, which was the reinstatement quote.
Okay.
You testified that it was your understanding that Northwest trustee this document came about because RCO requested a reinstatement in the context of the mediation. Is that accurate?
Yes.
And do you have an understanding or a belief as to why RCO would have requested a reinstatement quote from Northwest Trustee Services?
Usually the servicer will won't provide that directly because they don't have our fees and costs. They'll usually have the trustee issue the quote.
So it's fair to say that actually I don't want you to, strike that. So is it fair to say that the procedure set by the servicer is that the trustee requests reinstatement quotes?
Yes.
Payoff quotes as well?
Yes.
Okay. I don't think I have anything else.
I'm gonna have a couple follow-ups. Let me refer you to exhibit, while you have 5 out, could I have you locate exhibit 20, the assignment?
Okay.
Now, in exhibit 5, Mr. Stenman, Northwest disclosed to my client that the owner of the note is Freddie Mac. Is that correct?
Yes.
And in exhibit 5 as well, my client is informed that Sandar is the servicer. Is that correct?
In exhibit 5, yes.
But in exhibit 20, the assignment of deed of trust, if you were to look at exhibit 20, MERS is the one that assigned the beneficial interest in the deed of trust, is it not?
It indicates that in the assignment, yes.
Okay. So when you recorded the assignment of deed of trust onto the public records, did that not affect the chain of title on my client's property?
Chain of title?
Yeah.
Yes.
Okay. So even though you didn't collect money from Sandar for recording it, it was recorded at your doing. Northwest Trustee did that.
Yes.
Objectable form.
Okay. That's all I have.
Okay, the time now is 3:08 p.m. And this recording is a correct and complete record of the testimony provided by the deponent today, Jeff Stenman and Lucero versus Bayview Loan Servicing et al. 213 Civil 6020 RSL, taken 6 June 2014. It is contained on one SD card. We're off.